Hello friends and welcome to the Polity Primer series of Drishti IAS. My name is Pragya. From today onwards in Polity Primer, we are going to discuss about the major constitutional amendments. So the title of our today's discussion is the first constitutional amendment. In this discussion, we are firstly going to study about what was the Constitution First Amendment Act of 1951. Then we are also going to see the articles that were amended by the first constitutional amendment. Then we are also going to analyze the reason for the first constitutional amendment. Then we are also going to see its implications, and lastly we'll see some of the questions for your preliminary examination and a practice question for your mains examination. So if I talk about the background of our today's topic, the first constitutional amendment is in challenge before the Honorable Supreme Court of India by way of a public interest litigation. So basically the petitioners are arguing that the changes that have been introduced by the first constitutional amendment in the freedom of speech and expression, restricting the freedom of speech and expression, are against the basic structure doctrine. So this brings us to the moot point of our today's discussion, that what was the first constitutional amendment about? So the first Constitutional Amendment Act, passed in the year 1951, marked the first of many changes in the Indian Constitution. And whenever I teach you about the Indian Constitution, I always mention that yes, it is a very organic document, it is not a static document, and that is why Article 368 has been inserted in the Indian Constitution. That means you can amend the Constitution to make it adaptable to the changing times in the society. And the first constitutional amendment happened just after 15 months of the enforcement of the Constitution of India. Okay. The primary objective of the First Amendment Act was to address certain legal and constitutional challenges that arose in the early years of the Republic of India. So basically, if I talk about the history, the government was trying to bring in agrarian reforms, but the Supreme Court cases such as the judgment in the Ramesh Thapar case, Kameshwar Singh case, Brij Bhushan case, then State of Madras versus Champakam Dorai Rajan. All of these legal judgments paved a restrictive approach in bringing any kind of reform in the Indian society. So in all of these cases, land reforms or agrarian reforms were not allowed by the Supreme Court because it held that they were violative of the fundamental right to property. At that point of time, right to property was a fundamental right. So to overcome all of these difficulties in bringing major agrarian reforms, the government planned on amending the constitution, and hence the first Constitutional Amendment Act was passed by the then government. Moving forward, the major changes that have been brought by the first Constitutional Amendment Act can be divided into the following heads. So the first is the land reforms. So one of the most significant aspects of this amendment was related to land reforms. As I was explaining to you that yes, the government wanted to bring agrarian reforms, the government wanted to abolish the zamindari system, but as right to property was a fundamental right, the courts were rejecting them. Okay, and it allowed the government to impose restriction on the right to property. And this amendment inserted Article 31A and Article 31B in the Indian Constitution. So basically Article 31A was inserted to abolish the zamindari system, and Article 31B stated that any law that will be placed in the 9th schedule was also inserted by the first Constitutional Amendment Act, and any law placed in the 9th schedule will be out of the judicial review, and this was to save the land laws from lengthy litigations, lengthy cases. Okay, this was necessary to implement land reforms to address issues of landlessness and unequal land distribution, because we had a colonial past in which we saw that yes, the land was basically owned by the zamindars or the landlords. So the government wanted to abolish the zamindari system. Okay, moving forward. Then there is recognition of zamindari abolition, as I was explaining to you that yes, the amendment validated the zamindari abolition laws enacted by various states which aimed to abolish the intermediary landlord system, and that is why we inserted the 9th schedule. That is why we inserted Article 31 Clause A and 31 Clause B. This was a significant step towards equitable distribution of land and resources. Moving forward. Then there is reservation of seats, and this basically was the outcome of the Supreme Court decision in the state of Madras versus Champakam Dorairajin. Champakam Dorairajin, in which the Supreme Court said that the term reservation is not explicitly mentioned in the Constitution, and hence you cannot give any reservation. So Clause 4 was added in Article 15 as the country felt the need to make special provisions for the backward classes or for the scheduled castes and scheduled tribes. So basically after this judgment, Clause 4 was added in Article 15, and this was the birth of reservation system in India, because the country wanted to undo the historical injustices that was being done to various castes in India. Okay, and it also stated that Article 14, right to equality, does not preclude the state from making any kind of special provision for any vulnerable group in India. Moving forward. Then there were restrictions on freedom of speech and expression. So the First Amendment Act also made changes to Article 19 Clause 2, which deals with reasonable restrictions on the freedom of speech and expression. So before this amendment, the word reasonable was not there in Article 19 Clause 2. It was added by this amendment, that is the First Constitutional Amendment Act. Okay, and the amendment aimed at clarifying and broadening the scope of permissible restriction on 3 grounds. So the grounds of public order, friendly relations with foreign states, and incitement of an offense. Were added for the very first time in Article 19, and hence we allowed reasonable restrictions on the freedom of speech and expression of people in India. Moving forward, let us understand and see which articles have been amended by the First Constitutional Amendment Act. So firstly, as I have explained, Article 15 added Clause 4. Article 19, addition of the word reasonable in Article 19 Clause 2, and the government also said that yes, we can nationalize the trade, and we can prohibit the certain trades from happening, and it would not amount to any violation of Article 19 Clause 6. So this was also added by the First Constitutional Amendment Act. Then there is Article 85 and Article 87, which deals with the summoning and prorogation of the houses. Before the amendment, basically the parliament used to sit for only 2 times a year, and the president was supposed to address each session of the parliament. But now all of this has been removed. The parliament sits after every 6 months, a gap of 6 months, and only the first session of each house of the parliament has been addressed by the President of India. He is not required to address each and every session of the parliament. Same is the case with state legislative assemblies as well. That is why we amended Article 174 and 176. Then Article 341, 342, 372 and 376 also saw some minor changes by the first Constitutional Amendment Act of 1951. Moving forward, let us understand the reason for having the First Amendment Act, because it was done just after 15 months of the enforcement of the Constitution, and we did not even have our first general elections at that point of time. So basically it was a result of influence of socialism. We were trying to bring in the agrarian reforms. Our first Prime Minister, that is Pandit Jawaharlal Nehru, was very much influenced by the idea of a welfare state, was very much influenced by the idea of a communist state that works for the welfare of its people, because we had a troubled colonial past, and that is why he believed in socialism. He believed in creating an idea of a welfare state, and that is why he said that no, we firstly need to end the zamindari system or the land, we need to bring land reforms in India. So our first PM was an ardent supporter of agrarian reform, which he regarded as a process of social reform and social engineering. And the center wanted to remove any possibility of such law being declared invalid by the courts, and hence they amended the Indian Constitution and they inserted the 9th schedule. I have already explained to you in my previous slide that yes, 9th schedule was inserted, and Article 31B specifically mentioned that the laws which are placed in the 9th schedule are outside of the scope of judicial review by the Honorable Supreme Court of India. But this proposition has been changed by the Honorable Supreme Court of India in a landmark case that is also known as the 9th schedule case. So kindly let me know the name of the case in the comment box below. Moving forward, let us understand the implications of the first Constitutional Amendment Act of 1951. So, under the provisions of Article 31, laws placed in the 9th schedule cannot be challenged in a court of law on the ground that they violated the fundamental rights of citizen. But this position has been changed by the Honorable Supreme Court of India, and you are definitely going to tell me the case name in the comment section below. Article 31 Clause A has vested enormous power to the state with respect to the acquisition of estates or taking over management of any property or corporation in public interest. It sought to exclude such acquisitions or from the scope of judicial review under Article 14 and 19, because the state was trying to have an agrarian reform, and that at that point of time right to property was a fundamental right. So all of this was very necessary, and definitely it gave much power in the hands of the central government. And the most important implication of the first Constitutional Amendment Act is the enactment or the addition of 9th schedule, because it kept the laws which were placed in the 9th schedule outside the purview of any kind of judicial review. With this, we come to a conclusion of our today's session. We have seen the first constitutional amendment of the Indian Constitution. We have also analyzed the articles amended. We have also seen the need for amending our Indian Constitution, and we have also analyzed its implications. Now let us study about some of the questions that are important from your prelims perspective. So practice question for prelims. Your question is, the 9th schedule was introduced in the Constitution of India during the Prime Ministership of, and this is a PYQ that has been asked in the year 2019. So option A is Jawaharlal Nehru, option B is Lal Bahadur Shastri, option C is Indira Gandhi, and option D is Morarji Desai. So correct answer will be option A, Jawaharlal Nehru. The second question is, which aspect of the Constitution did the first Constitutional Amendment Act primarily focus upon? Your option A is fundamental rights, your option B is directive principles of state policy, your option C is preamble, and your option D is federal structure. So kindly drop your answers in the comment box below, and I will reveal the answer in the next episode. Moving forward to the last question for our today's session. Which court case played a pivotal role in the context of the first Constitutional Amendment Act and its impact on property rights? So option A is Golaknath case, Option B is Keshwanand Bharti case. Option C is Indira Gandhi versus Raj Nareen case. And option D is the Minerva Mills case. So I am revealing the answer for this question, and the answer for second question will be given by you to me. So for the answer of this question is option A, Golaknath case. Now let us discuss a practice question for your mains examination. So the question is, critically analyze the First Amendment Act 1951 of the Indian Constitution. So firstly, you will write about the history of the first Constitutional Amendment Act. You will write what the Amendment Act was all about. You will write about the, or mention in brief about the articles that have been amended, reasons, implications, etc. Whatever I have discussed in my discussion today, you can mention all of those points in brief, and you can conclude very holistically that yes, to bring certain reforms in the Indian society at that point of time, this was a major change that happened during that time, and you can conclude very holistically. And you can also write about the landmark decision of the Honorable Supreme Court in the Shankari Prasad versus Union of India, in which the constitutional validity of the First Constitutional Amendment Act was approved by the Honorable Supreme Court of India. I hope this session was insightful for you. If you have any feedback regarding this session, kindly drop it in the comment box below. If you liked today's discussion and found it to be helpful, kindly like the video and subscribe to our channel for more such updates. If you want to get the PDF of this session, kindly join our Telegram channel, the link which I have shared in the description box below. Thank you.
For more informative content, like, share and subscribe, and do not forget to press the bell icon to get the notifications.